I remember that, but he still went on. Okay. That's fine.
It's 2 o'clock. I call to order the meeting of the Code Enforcement Board for the City of Tarpon Springs, December 12, 2013. I'll rise so that Tom can lead us in prayer.
Heavenly Father, send down your blessing on this meeting of the Code Enforcement Board. Give the board members a clear sense of duty and lead them to a faithful discharge of the same. Direct them in their deliberations at this meeting so that all things may be done to the glory of thy name and the welfare of the people of the city of Tarpon Springs. This we pray. Amen.
Please turn toward the flag and recite the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Okay, let's go.
Bobby, if we could have a roll call, please.
Mr. Sansoda?
Here.
Ms. Casey? Here. Mr. Kramer? Absent. Mr. Bessie?
Here.
Mrs. Archer?
Here.
Mr. Demasis?
Here.
Mr. Solinsky?
Here.
Mr. Plunkett?
Here.
Mrs. Dabbs? That completes your roll call.
Thank you. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires that any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the violator, each party is asked to give a closing statement, first by the city and then by the violator. After those 3 steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the secretary of the board.
Do you swear the testimony you're about to give is whole truth and nothing but the truth? Yes. Thank you. Be seated.
And if you would, please turn all of your cell phones off, or at least turn them to silence. And we will proceed with item number 2 on the agenda.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. This is case 13-800000913. The property address is 309 East Tarpon Avenue, and the property owner of record is the Signature Group of Tampa Bay. Is there anyone in the audience for this property? Could you review these photos and just verify that they are of your property, please?
And sir, if you would mind, after you review the photos, I will have you sit over here and speak your name and address into the microphone.
Okay.
Thank you.
Anthony Sarukas with Signature Group of Tampa Bay.
Okay. Thank you.
On September 26th of 2013, I received an email from Renee Vincent in Planning and Zoning. She stated that this property owner had failed to obtain a certificate of appropriateness from the Historic Preservation Board for a new parking lot. This property was in violation of Codes 109.00, Certificate of Approval Required, Appendix B, Smart Code Adopted, and Section 4.7.1 of the Smart Code, Parking Location Standards. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on October 4th, 2013, and a notice of hearing sent first-class mail and certified return receipt on November 5th. A site visit was conducted prior to each notification being sent. The certified document was returned. The property was posted on November 22nd of 2013. I was going to have Renee Vincent, the Planning and Zoning Director, address this, but she is out sick today. Rodney, are you aware of this case at all? Would you have anything additionally to? Okay. A site visit was conducted yesterday, December 11th. There is no active permit for a fence for this property. No fence has been erected, and approval from the HPB or Historic Preservation Board has not been obtained. This property is in violation of Codes 109.00, Appendix B, and Section 4.7.1. I'm recommending a compliance date of January 13th of 2014, or a daily fine thereafter of $50 a day.
Does the board have any questions for the city?
Yes. Where, in fact, is this fence going to go?
Along the front of the property
The front,
to keep it from being used as a parking lot.
okay. And that will go along with the historical
Then
society?
he would not need HPB approval for a parking lot. That would be considered his front yard.
Oh, okay, thank you.
The fence would restrict him from being able to use it as a parking area.
So his visitors, guests, whatever, would not be able to park in
In his
front of
front
his
yard.
house with that fence in
Correct.
place?
That's correct.
Thank you.
You're welcome.
Any other questions?
This is a home?
Yes.
Okay, Mr. Anthony, if you would have any statements that you would like to make.
Yeah. I had contracted with a local fence company. They backed out of the contract, and then there was an issue, I guess, with the licensee for the business. They resecured a new licensee, apparently, and contacted me and said that they would complete the fence, and then never did it. So I have the Burris building I'm working on, another building on the sponge docks, and I just got like 6 projects simultaneously being redeveloped in Tarpon, and the fence sort of made its way down the totem pole as far as things that needed to be addressed, and I'm in violation. The thing that I did discover, though, yesterday when trying to do some research about it, is that because of the setback on the property, I actually wouldn't be violating the smart code if I put a parking screen in, and I would be allowed to park in the front because the setback is sufficient to be able to support parking in the front. Also, all neighboring properties that have a curb cut in front of their properties all have paved driveways, concrete paved driveways. I went the route of turf block at the recommendation of the city because you cannot just go and pour concrete or get permits to pour concrete in the district any longer. So I went this route for ground stabilization, and there was a number of other issues with the property as far as from inspection reports after I purchased it, I guess about 18 months ago. So originally I was planning on putting in just crushed shell, and the city said absolutely not, you cannot do that. So I went the $13,000 route and went and put the turf block in myself to get that, nicely leveled, so I wasn't ending up with a big pool under the house, which is what kept happening. Tarpon's awesome, and when it rains, it puddles under these older houses. So I was able to eliminate that issue by working out that front yard. But my permit has expired at this point, so I'll have to reapply. for a fence permit. And I guess the best process would be for me to go ahead and apply for a special use for that to be allowed for parking, because there's a number of antique and art galleries that are closing, and I've been contacted by a number of people about using it as that type of a use. And so in doing research, I mean, I can't pull cars through that back alley. If you're familiar with that alley, it's really poor shape. There's power poles there that are pretty much like right in the right of way. I mean, I can't pull my truck down it. I can't see how I'd be able to support opening a business there to be able to park in the back. So I guess I just have to go back to the drawing board and look at my site plan, the initially approved site plan and the new proposed site plan, and say, all right, for me to reasonably be able to accommodate a business in this location, these are what the setbacks are, this is what the screen should be for parking screen, and be able to at least have 3 or 4 spots there. Originally, when we were talking about the turf block, I was going to turf block the entire property, and that was okay. After talking to people here at the city, they're like, look, we want some more green space in here, so why don't we just go ahead and why don't you sod it? So I went ahead and I sodded the rest of the property and maintained it. And if you look at pictures of the property from a year ago or so to now, it looks tremendously better than what it did when I picked it up. So I guess I just have some more stuff I need to work on before that January the 13th date, and hopefully I don't sit here again.
So the January 13th date, you think, is a date where you could reasonably have,
I mean, I can throw a fence up there. It would be defeating the purpose. I think it'd be a waste of money, if I can actually get it approved. But there won't be an HPB meeting that would be able to see this, because I need a PE to stamp my new site plan to establish parking for it to be approved. So I don't know if January the 13th is a reasonable time frame for me to be able to get the appropriate stamps from an engineer, applications submitted, approvals, and installations to be done.
what would you
between now
consider
and-
to be a reasonable time frame?
I mean, is 60 days more doable for,
So March 13th,
if
give or
that's,
take?
if that's okay?
In speaking with Rodney and asking him about the time frame to go through all that, we're in agreement with the request.
Does the board have any questions for the violator? Okay. I'm going to go ahead and close the public portion of this. Thank you for your testimony.
Okay.
And leave it to the board. Does the board have a motion that they'd like to make?
I'll make a motion.
Okay.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violation, Section 109, Certificate of Approval required, Appendix B, Smart Code adopted, Section 4.7.1, Parking Location Standards, was enforced. The respondent has until March 13th, 2014, to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter the respondent remains in violation of the said code sections.
Second.
Okay, board discussion, and Bobby, also, would you receive those photographs into evidence, please?
Yes, sir.
Any board discussion? Bobby, if we could have a roll call, please?
Mr. Plunkett,
Yes.
Mr. Solvinsky,
Yes.
Mr. Demasis,
Yes.
Mrs. Archer,
Yes.
Mr. Bessie,
Yes.
Ms. Vacacy,
Yes.
Mr. Sensoda.
Yes.
You may
Okay, March 13th it is.
Thank you.
That really looks nice.
Well, eventually, we'll see. One step at a time. Thanks, guys. Have a good day. Happy holidays.
You
Thank
do the
you.
same,
You too.
same.
Okay, item number 3.
You mean number 6?
I mean, number 6, I apologize.
This is case 13-8000988. The property address is 801 Riverview Lane, and the property owners of record are Jerome Harrell and Marlene Siegel. This is a repeat violator. Previous cases 12-800000812 for codes 8-40 and 8-52. On November 5th, I noticed that this lawn was overgrown. The property was in violation of codes 8-40, duty of maintenance of private property, as a repeat violator. Okay. And 8-52, nuisance prohibitions as a repeat violator. And I understand one of the property owners is in the audience. Are you Marlene? Could you take a look at these two photos, please? And verify that was your property? Yes. Okay.
If I could have you please come over there, speak your name and address into the microphone.
Marlene Siegel, 4575 Pet Lane, Lutz, Florida.
Thank you.
The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of hearing, first-class mail, and certified return receipt on November 7th of 2013. The property did come into compliance on November 15th of 2013. I posted the property on November 22nd and conducted a site visit yesterday, December 11th. The property is still in compliance. The property was in violation of codes 8-40 and 8-52 from November 5th of 2013 until November 15th of 2013. I'm making a recommendation of a daily fine of $10 per day from November 5th to November 15th, 10 days total with a total fine of $100.
Does the board have any questions for the city? And Ms. Siegel, would you like to make a statement?
Yes. I had hired somebody when I found out that the property wasn't being taken care of. I'm going through a divorce, so I'm trying to manage everything by myself. And when I found out that the property wasn't being taken care of, I went out, got their lawn mowed, and I hired somebody who was supposed to be taking care of it. And it wasn't until I found out from Cindy that they weren't taking care of it, and I had already paid them. So as soon as she told me that it was back not in compliance, I got a recommendation and hired somebody who is now going to regularly take care of it. So it wasn't out of neglect. I really thought it was being taken care of. So I beg your forgiveness one time, and I do have somebody who will regularly take care of it. There's no one living out there because the previous renter had a fire in there. So I'm trying to get the divorce done so that I can actually do something with the property, but right now it's in limbo because X is MIA.
Okay. If you don't want to answer, you don't have to. The fine, is it a hardship?
Yes.
Okay. Does the board have any questions for the violator?
I do. Ms. Siegel, the fine you're saying is a hardship.
I am trying to deal with accidents. He totaled his truck, wiped out telephone poles. I've got lawsuits out the wazoo chasing this man.
I'm sorry, I can't.
And so I'm trying very hard to put out all the fires one at a time and deal with everything.
Could we extend the date for the fine?
I really would rather not have to pay it. I mean, it cost me more than $100 just to leave work and drive here today. I live 45 minutes away, and it wasn't out of neglect. It was, I really thought I had already paid somebody to mow that property. I paid them more than $100 to take care of it and maintain it. So talk about due diligence. I've paid 3 times over.
Well, we have a minimum.
No.
No.
No, we don't.
I guess we got rid of that too. I'm sorry.
I really am trying desperately to get everything taken care of. Plus go through a divorce, plus maintain all the properties.
Long time ago.
Is there a way if we didn't have a fine on this, that we could flag it, that if it happens again, that we are reminded that we gave her a break?
It's totally at your discretion.
You know,
I just made a recommendation.
Because I could see
So if it,
for going to fine, but if, you know, there's a
Absolutely.
situation with when you're not
Absolutely.
living there that it can be neglected. But I'm all
Absolutely.
for-
I would very much appreciate that.
But if it happened again, I'd want to know that we gave her a break and then, you know, came back to write
I
us.
think it should be noted, this is a repeat violation, though. This is not a first-time violation.
That's,
Yes, sir, but I had hired somebody, I don't live out here.
That's-
So I hired somebody, didn't hear anything, I was assuming it was being taken care of.
Okay, but you still have some responsibility.
Absolutely, and as soon as I found out that it wasn't being taken care of, I immediately hired somebody different.
So you didn't take care of it, you were in violation, then you
No,
had...
I did take care of it the first time. I personally went out and took care of it.
First time, okay.
Yes, sir. And then
Second
I
time
hired
you
some.
hired somebody, but then they didn't really do what you asked them
No,
to.
after I went out and actually took care of it and made sure it was physically done, I hired somebody who was supposed to go out every 3 weeks and repeat it. So from the first time that it happened, I thought somebody was out there mowing it. And then I found out that they were not mowing it. And that's when I hired somebody based on Cindy's recommendation. He went out there, got it taken care of, and he has promised to continue to do that until the divorce is done and we either sell the property or whatever's going to happen with it.
Does the board have any other questions for the violator?
Sorry.
Okay, I'm going to go ahead and close the public portion of the testimony and keep it among us. Would anybody like to make a motion at this time?
well, I move based on the testimony, evidence, facts presented in law that the respondent was in violation of Section 8-40 and 8-52 from November 5th, 2013 till November 15th, 2013. Okay, wait. I kind of got ahead of myself here. All right, from those codes, okay, I'm all right. I would say no fine for those days.
Do we have a second?
I'll second that.
Okay. Board discussion? As a repeat violator, Tom, does this set a precedent for a future fine?
No?
None whatsoever. Okay. Bobby, a roll call, please.
Mr. Plunkett,
No.
Mr. Slavinsky,
Yes.
Mr. Demasis,
No.
Mrs. Archer,
Yes.
Mr. Vesey,
Yes.
Ms. Vaquesi,
Yes.
Mr. Sansoda.
Yes.
Your motion carries 5-2.
All right. So no fine today, and
Thank you.
hopefully we can
I promise
keep
it'll
it
be
up.
kept up with.
And we'll proceed on to item number 7. Is there anybody in the audience for 23 South Walton Avenue? If you'd please, first of all, I have some pictures for you to approve. And Bobby, will you receive those pictures into evidence that you had just gotten?
Yes, sir, I have.
And if I could have you state your name and address into the microphone, please?
My name is Milad Mikhail. I'm the leaser in this property. And this is with the Saturday.
I just need your
Oh,
name and address right
sorry.
now. Thank you very much. And Cindy?
This is case 13-800000999. The property address is 23 South Walton Avenue. The property owner is Clanaris Properties, LLC, and the business owner is Easy Stop and Shop, Milad Mikhail. This is a repeat violator. Previous cases 13-800000741 and 13-800000967 for Code 181. This was proactive on November 9th of 2013. I noticed that this business owner had put his illegal signs back up. On November 10th of 2013, the signs had been removed. This is the third consecutive hearing that this business owner has been brought before you. This property was in violation of Code 181, signs specifically prohibited as a repeat violator. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, and the business owner were sent a notice of a hearing, sent first-class mail, and certified return receipt on November 13th of 2013. The property came into compliance on November 10th. The property was posted on November 22nd, and yesterday I conducted a site visit. The property is still in compliance. This property was in violation of Code 181.00 from November 9th of 2013 to November 10th of 2013 as a repeat violator. I'm making a recommendation of a fine of $500 for the 1 day.
Does the board have any questions for the city?
Cindy, did you say this was the third time?
Yes, ma'am.
Okay, Mr. McKay.
On the, excuse me.
Sorry.
On the 9th, did you actually go in and talk to the owner?
No, sir.
That, okay, so maybe he saw your vehicle or what and took him down on the 10th?
I have no idea.
Okay.
I have a question. In regards to the sign ordinances, is it painfully clear by, if, without having that sign ordinance, and I know that we rely on you to interpret that, but if you were to pass that ordinance down, is it painfully clear exactly what is allowed and
Yes.
what isn't?
Yes. And I had been in to speak with the gentleman, at least on one occasion, to explain the ordinance to him and offer other suggestions as to how he could market his business.
And to the best of your recollection, what does that ordinance read? Does it say, hey, you can't stick anything on the post in front of your
It
building?
has a list of prohibited signage, and all new signage requires a permit from the city.
The former two violations, were those signs in that specific area that they are in this one?
They were, yes,
So he knew that those were illegal?
yes,
Okay,
yes.
okay.
Was he fined at that time?
The first case was to be established, and the second case, I don't know what he was. Bobby, do you have access to that?
I did not bring,
Okay.
that case.
Let me see if I have it in my backup.
I have it.
No, I don't have the old cases with me.
Is that
Hang on.
bond?
I'm sorry.
Okay.
We have it right here. It's
Oh,
all right.
okay.
Thank you, Mr. McHale.
Okay, that was to establish.
While you're finding that, did you want to read the procedure?
The code is very, very long.
Is there a spot in there that kind of lists it out?
Well, section 181.00, it's titled Signs Specifically Prohibited. This is the following types of signs are expressly prohibited except as otherwise provided by this article, and there's a long list,
Wait a minute.
maybe 30 different signs.
7,
I'm not
this was to be
particularly
established.
sure which sign
Last one.
category that it falls under, but
And since you were kind of looking on my behalf in my question, the reason that I ask is, we have a lot of sign cases that come before us, and this one repeat, fairly severe consequence. I've been paying a lot of attention to signs lately, and I'll be honest, sometimes I can't seem a rhyme or reason, and I'm just trying to get a better grasp of because we have been relying exclusively upon our officer and assume that everything is exactly right.
Well, it's exactly right, and Tom sees to that. The only time that I've seen some really good differentiation is when you get down to the line, the property, the county line, not the county line, the town line, and Palm Harbor and Tarpon Springs weave in and out every once in a while, and that's what obscures things down a ways. But if you're in the middle of Tarpon Springs, I don't know.
Chairman?
Yes, Cindy?
On the last case, property owner was found in violation for 4 days, and a fine of $100 a day was imposed.
Okay. So a $400 fine on the second violation.
Do you know if that's been paid?
No. I just know about it like couple.
Okay, so he doesn't pay the.
Any other questions for the city?
I have one question. You had stated without applying for a permit, if this individual applied for a permit, would those
No.
signs fall under that category?
No.
Okay,
They're
thank you.
strictly prohibited. They're not
Okay.
allowed at all. He would not be able to get a permit for them.
Okay, thank you.
Mr. Chairman?
Yeah.
Yeah.
I have not been on this board as long as some of the people in this room, other than my previous term on the board. And this is the second violation since I have been coming here in a short period of time. I agree with the city officer. This is almost flaunting by putting the signs up the day after this fine was imposed. And I have to believe that this is not only a direct violation, but also a slap in the face to the board after they find it.
Yeah. Do you have any questions for the city, Al? or-
No questions. for the
Okay.
city.
We'll have a discussion portion after we make a motion. Any other questions from the board for the city? Would you like to make a statement, please?
Yes, sir. The first violation, I had a sign for my new food section by a sign company, and after they put it in, and I found out that it didn't pull any permit, didn't do nothing, so she gave me the violation. And once I got the violation, I took all the sign down, and my business dropped to 50% because people think we closed out. That's the first violation. The second violation, I was away with my family. My family just came visit me from Egypt. I took them for like a week away. And my employee, he think the business was very slow. Especially we have a murder case next to my store. After that case, the business was very, very down, not even paying my bills. One of my employees, he hanged this post, and I wasn't there. And I just found out I was even have a fine like last week. That's the second violation. The third violation, I want to refresh her memory. I was inside the store that time, and some customers tell me, somebody take a picture of your store. I went outside to her. It was a Saturday, and I told her, then I didn't know that we don't allow Saturday, because I see like the weekend a lot of signs outside, house for sale, all the signs in the weekend like I see it's normally you don't have to do it in the weekday. I asked her, is not allowed to do it. That's why she seen the next day we don't have the sign, because once she left, I take all the sign down in the same day. And I spoke with her, she was in the car. And even I asked her why the cross street had the signs there, and still since the first violation I was here in this court, and I told her why they don't have, she told me they have a permit. And I went to the city yesterday and I asked them if they have a permit. They told me no, since 1999 they never have a permit. And I have a picture of all the cross street, same thing, my competition. And also the same, I don't understand why only me. I talked to her very nicely. I told her I didn't even know. It's a weekend, we don't put signs. And I took it right away in the same moment she left. Because I don't want any violation. Because I told her here last time I was here, I'm obeying the law and I want to work in the law. Even I have a company boasting with the contractor and new signs to my business, because all customers think we close out since we took the signs down. So it's $400. It's killing me that time recession that my business is down 50%. And I don't understand, like, when you're asking something to people responsible. She was so mean to me. Like, last time when I was here, I told her, why me, not the cross street? They have a lot of violation. Same business, same stuff.
Unfortunately, I cannot address across the street today.
Okay, I'm going to take this to the different step.
Take pictures, but
okay.
we have your business.
The point, I'm trying to understand. Sometimes you don't understand everything in the law. I went to her, I told her, I saw it as a weekend. Said, no, it's a 7-day week. I said, okay, I'm sorry, I will take it out right away. And this has happened in my son's name.
Well, unfortunately, with regard to upholding the law, even though an employee may have made a mistake, it's still the responsibility of that mistake does rest with you.
Excuse me, sir. Once I got back, I saw the sign. I told them, why you put the sign down? That's why I stayed for 4 days. After I came back, I took it right away because I know it's not legal to do it. That's why this was only 4 days there. The 4 days I was away.
It's a shame that your employees did not realize the magnitude of violating this ordinance.
They were scaring that they don't lose their job because now I have to cut them out and I stay in the store for at least 12 hours a day just to cover my bills.
Does the board have any questions for the violator? Mr. Mikhael, this is a third time that you've been before us, and that's how come you're seeing a resistance to leniency, because it is a third time, and understandably, you've got an excuse for the first time, and possibly a employee mistake for the second time, but being here the third time, I'm just not clear why I am seeing you for a third time.
Okay.
Now, I know this is an employee excuse, but the buck stops at your desk. You're the owner,
Yes, I'm the owner.
and you're here
The
for a
third time, I saw a lot of signs the weekend. I saw it only the weekday. Maybe this is the problem. And she came right away in the time I put the
Well,
sign.
regardless of whether
Yeah.
she came, the sign was up, the building was in violation. Had you not had a friend or a person of interest say that somebody took a picture, then you may be looking at $1,000, $1,500 fine because you weren't then aware. But the fact is, somebody told you that the city took a picture of your
No,
property.
she
That's
didn't
when
tell
you
me
knew
the
to come to
city.
your
He told me
property.
somebody taking a picture. I went outside to see who's taking picture of my business.
Right, but if nobody told you that possibly this fine would be a lot larger than that.
No,
You
I was.
shouldn't rely on somebody telling you that the city took a picture. You need to put some safeguard into place.
No, I'm just was planning to put in the weekend like the others do. I didn't know that weekend also. It's not prohibited.
You didn't realize it was,
No, I was putting out for only Saturday, Sunday, at least to get some business, people attention. Because it's a lot of parade outside in the street, a lot of festival there's, people driving around. So I was trying to get in more business.
yeah. Well,
And
the only thing
I swear, like I promise, I will swear, I didn't even know that weekend we couldn't. Because I see a lot of people doing it, a lot of people in the street. I only in my life working and go home. Like
Okay. Board, any more questions for the violator?
No, not for the violator.
Okay, Mr. McHale, I'm going to go ahead and close the public portion of the hearing, and we'll discuss among ourselves and decide what to do. Does somebody want to make a motion?
I'll make a motion.
Okay,
I move based on testimony, evidence, facts presented in law, at the time of the alleged violation, section 181.00 of the Code of Ordinances of the City of Tarpon Springs was enforced. The respondent must pay a fine of $500 per day shall be imposed each day thereafter in violation of said code section.
did he read the correct one? You want to read the repeat violator, Al?
Oh, sorry, okay.
No problem.
I move based on the testimony, evidence, facts, and presented in law that the respondent was in violation of section 181.00 of the Tarpon Springs City Code of Ordinance from the initial inspection date of November 22nd, until the property is brought into compliance. A fine of $500 per day is imposed until compliance is achieved.
No, that's not right.
No,
The date is November.
Oh, November,
November 9th.
November,
It was
one day
November 9th.
fine.
November 9th. Sorry, I took it off the other sheet. Sorry. I move based on testimony, evidence, facts presented in law that the respondent was in violation of section 181.00, Tarpon Springs City Code of Ordinance from the initial inspection date of November 9th. Until the property is brought into compliance, a fine of $500 per day is imposed until compliance is achieved.
If you could just add that the date is November 9th to November 10th. Just add that onto your motion, and
It's just.
He's
for
in
one day.
compliance now.
It's in compliance now, but it's
Yeah,
just for the
the
one
property
day.
is, okay, I'll say, make it again, you know. I move based on testimony, evidence, facts presented in law that the respondents was in violation of section 181-00 of the Code of City Springs, Tarpon Springs City Code of Ordinance from the initial inspection date of November 9th until the property was brought into compliance on November 10th.
there we go.
A fine of $500 per day is imposed until compliance is achieved.
thank you, Al. Do we have a second?
I second it.
Okay, Bobby, please receive that packet into evidence.
Yes, sir.
Board discussion.
Cindy, did you say that they paid the $400?
Just our discussion.
I don't
They-
believe that they did.
Okay.
He said that he didn't.
I don't know where it to pay to.
Yeah, this discussion must remain with the board right now.
Yep.
What we
I
have
was- that's what I
before us.
By recollection, he said he didn't.
Yeah,
And you also did say that you had given him ideas of how he could help his business without the signs.
Not this
and-
one time, but the previous case. I actually went in there and spent about a half hour with him, giving him some ideas.
Okay.
Well, you know, this extends out to the property owner. This, you know, the guy that rents him that store has to hope that he stays in, you know, within the boundaries of our laws, or else he's gonna get caught up in this thing. And I really don't like the Saturday. He thinks Cindy doesn't work on the weekends, and so let's put the signs up on the weekends.
I do
That's
work
exactly
once.
what that was
I do
about.
work
Well,
an occasional Saturday.
right.
and-
But I think that people think the city closes down at 5 on Friday, and so let's put illegal signs up on Saturday and Sunday and just pull them back down, and it didn't happen that time.
I did want to make a comment with respectfully to Hal, is that to assume or to say that that was a personal affront to the board or that there was a slap at the board, there's no intention there, and we can't take things personally that way.
I agree.
I think that was been carefully delineated by our chairman and by our rules and bylaws, is that we cannot take these things personally. There's no personal affront to that. And then I would add.
Jim, you'll need to speak louder. The gentleman you're trying to address says he's not able to hear you.
Thank you, excuse me, so
Say what?
that I didn't think that those comments were in line with how we operate, that there's not any personal affront that he
Well,
was
say
trying
it's
to make
better
to
to
the
let him
board,
break the law.
even though he has been with us 3 times. And then I would just like to add, he has been fined $400 and $500 here, and that's a total of $900 for what I see as 3 cigarette signs. Now, is he in violation? Yes. Are the facts pretty clear? Yes. But I sure think we should think long and hard about finding a business in our community that are so hard to get and keep, irregardless of his reasons or excuses. $900 for signage. And verbatim for Mr. Trask, we can't really tell how that code reads, even though this person was carefully told by the code enforcement officer.
Did he pay the first 400?
No.
By his own admission, no. I'm just, this is just conversation.
Do you have an idea? of a fine?
$900 in sign fines?
Do you have an idea of a fine that you would like? We're not talking again about a previous fine, but this fine, Justin, do you have a,
No. No, I don't have another.
maybe you have something. I'm
I'm kind of at a loss. I'm as frustrated as anyone else, but I am at a loss for this sign issue in particular.
Well, when he was fined $400, he ignored it. And so, you know, 500, he's gonna probably ignore that too, but it's just, I don't know.
Excuse me, I'm not ignoring.
Feeling that
This, the public testimony.
You
I'm
can't
sorry.
speak,
Thank you.
sir.
I'm sorry.
I agree with the motion. I'm just,
Any other board discussion?
Call for a motion.
Well, we're going to have to call for a motion on this, and,
You already got one.
pardon?
You already have one.
we already.
You had a
You already
motion.
have a motion.
Oh, for heaven's sakes, I'm sorry, yeah. Okay, a roll call, Bobby.
Mr. Plunkett,
Yes. Was there a second to the motion?
Yes.
Yeah.
Okay.
there is, because Case made your second. Mr. Soblensky,
Yes.
Mr. Demasis,
Yes.
Mrs. Archer,
Yes.
Mr. Vesey,
Yes. Yes.
Mr. Casey,
Yes.
Mr. Sansoda.
No.
Motion carries 6-1.
Okay. Well, I'm sorry for the fine, but hopefully in the future, it will not happen. And,
It doesn't happen because I want to break the law. That's not, it doesn't happen this way. But,
I hope success for your business.
thank you.
Affidavits of non-compliance. Mr.,
He's not here.
It doesn't even, the sign wasn't there for like even an hour.
yeah.
After she told me it's not allowed, I took it out.
Unfortunately, the
you.
suggestion has been entered, and so now it's an official fine.
I move to accept the
Well,
affidavit.
no, there's, Mr.,
Mr. Lindiakis?
yeah, Mr. Lindiakis, if you'd like to come forward and state your name and address, and we'll just proceed to your case real fast.
Hi, my name's Manuel Lindiakis. My home address is 773 Anclote Landings Drive, Tarpon Springs, Florida.
You need to see if you're sworn in. Manuel, were you sworn in earlier?
Yes.
Okay.
What are we doing?
This is just an affidavit of
Manual?
non-compliance
Thank
now.
you, sir.
Oh,
Okay, when there's someone here in the affidavit of non-compliance, we're going to find out whether or not, you know, we have city staff, you know, present their case that it's in non-compliance, and Mr. Lindiakis would have the opportunity to respond to that. So, Cindy, you want to move? Oh, Anthony? Okay.
I don't think I've ever been at a meeting where this happened.
The only question you really to consider is the property in compliance or not as of the date that the board ordered it to be in compliance?
Okay. And city, Anthony?
Anthony Mastraccio, Supervisor Inspections, City of Tarpon Springs Building Division. For case number 13-800-00342, located at 119 East Tarpon Avenue, I did a drive-by yesterday inspection, and as of yesterday, it is not in compliance. It's under construction, has a valid permit, and has received numerous inspections, but it has not gotten final inspection.
Okay. Any questions from the board?
This is the one that had the bomb, or the explosion?
Yes, ma'am.
And there is signs that he is working to replace, repair. I mean, I've noticed the front soffit, and you can look through and see that the building is.
Oh, yes, sir. Yeah, it's come, they did quite a bit of work. It's come a long way.
So the problem is, he's not in compliance as of what we set up in a meeting prior.
Yes, sir. Compliance would be that a final inspection was performed and approved.
Was that our requirement, that it was through final inspection?
In actuality, what it is that he has to show that he's no longer in violation of all these International Property Maintenance Code sections. And the way that he can do that is tear the building down or fix the building so that these issues are resolved. And it just so happens that that can be accomplished by way of the final inspection.
That's right, you shared that with us when we had that meeting. Thank you.
Any other questions? So then
Let Mr. Lindiakis
Yeah, if
explain
you,
whether he
would-
thinks they're in compliance or not.
Well, good afternoon.
Thank you.
I was here before this board
Yeah.
July, and I didn't really, first time here before the board, I was pretty much in agreement so I could get started on the project. And then after I didn't know that after I spoke, I couldn't say anything else. I mean, this is the first time I did this. And this board went from wanting to fine me that same minute to give me 30 days to fix something. And we had almost 8 votes to give me 4 months to find an architect, run it through the Heritage Board, submit for a permit, and get it done in 4 months, okay? But I appreciate the time that you did give me, but some of the people on the board knew better than I, knowing that it was never going to get done, because believe it or not, it took me 4 months to get a permit, okay? I had to go in front of the Heritage Board. I promptly got the plan submitted to the Heritage Board. It takes 30 days to get in front of them. They wanted me to keep the exact brick design on the parapet wall. I agreed with that, but then I had to go back and get revisions for that. I submitted for a permit September 25th, okay? I didn't get a permit till November 15th. Why it takes 2 months to pull a building permit when I'm being fined supposedly because my building's going to fall down, okay? Yet, it took from September 25th to get a building permit. But the building department, they're working with me, nothing against, the time frames. So the question is, do I sit here and agree with everything like I did last time, or do I make a statement that some things I have to stand for? And the question is, based on your first opening statement, is this board's not to be fair, equitable, and just, and reasonable, okay? And I'm a lawyer, okay, but I didn't come in here with my lawyer hat last time, and I'm not coming in with my lawyer hat today, but I will say this. I've done everything I could. I'm spending over $100,000 to fix that building. I've got other properties in Tarpon. Every penny I've got, I spend in Tarpon. I grew up in Tarpon. I accepted a fine on my office sign that I really shouldn't have agreed to. They told me I didn't need a permit. I fixed the sign. I got fined $3,500 or whatever it was. I said, screw it. I'll pay the $1,800. I paid it, okay? If you guys can't be reasonable with me on this, as much as I'm trying to do, and give me enough time to get this thing fixed, you can give me a fine. You have the right to do that, okay? You wanted to give me a fine the same day, when really there was nothing even wrong with my building. It was messed up, but I agreed to everything, okay? If I get a fine, I'm not going to pay it. I'm a lawyer. I'll take it to circuit court. I'll get a video of the 9 votes it took to give me 4 months to pretty much, I gutted the whole building. I'm putting a new roof, new floors. It's going to be a brand new building, okay? You guys gave me 4 months to finish something that took 4 months to pull a permit, okay? And this guy over here is arguing with everybody, making a personal issue. Y'all, I couldn't believe what I went through last time, to tell you the truth. Okay, so let me just say this. I'm working hard to try to finish this job. I got the walls down. I got the structural components are fixed. I took that brick down. I got the thing framed in. I'm ready to knock this thing out. But I'm going to have to take a stance if somebody tries to put a fine on me for giving me not enough time to fix it. You follow me? I did everything I could. All right? I love Tarpon Springs. I grew up here. I'm going to live here till I die, whatever years I got left. But some things, and I'm busy enough, I don't even really need to file a circuit court action or go back in front of the board. But, what's fair, equitable, and just? The one fellow here was trying to tell everybody, hey, look, it's going to take 6, 7 months to do this darn job. I mean, come on. It took me 2 months just to get past the Heritage Board. Took 2.5 months to get a permit from the city. Yet I'm supposed to tear down a building, fix it, go through the permitting process, which that's not the easiest hurdle to jump over. I mean, the inspections, this takes time. So, I'm just asking that y'all be fair with me, okay, and give me a little more time to finish this darn thing. That's all I'm asking. But if I get fined, I'm going to go in front of the Board of Commissioners. If they don't agree with it, then I will take it to the circuit court, and I'll, waste everybody's time. And if a judge sees that video, he'll determine that I was not given enough time. It wasn't fair, reasonable, or just time.
I'm not going
Okay,
to,
that's it. I said what I had to say, because once
Okay,
I can't say
thank
it,
you.
then
Thank
you
you.
guys are going to start,
Yeah,
I
you
hope
know,
I don't go
I-
through that again.
You-
But
you
I said what I had to say, and I'm just...
Excuse me. I vaguely recall this, and it was 30 days, extended to 4 months. So I understand you were not in favor of the 4 months, or were you just not understanding the amount of time it would take to get a permit?
I didn't know it was going to take that long. I thought that we were going to be able to move this thing along, but, the Heritage Board, they didn't like what I did, and the design was very basic. I hired an architect, and supposedly he knows what the city likes. Apparently he didn't, because I had to change it. You follow me?
All right.
And then, it took, the time you gave me to fix it, that's how much time it took me to pull a permit.
Yeah,
The
okay.
day
so
I got
you've-
my permit was November 15th. And
So you
since
made an
November
honest
15th
effort to comply.
I'm
But
trying.
due to the logistics of the paperwork, I guess, or whatever. Okay. Do you have any other testimony that you would like to add at this time?
I would just I would respectfully request to give me a reasonable amount of time to get in compliance. That's all. I mean, I'm working out there. I got those scaffolding up there. I'm ready to knock this thing out. It's going to be a beautiful building when I'm done, and the city's going to be proud of what I'm going to do over there. I'm spending
Okay.
a ton of money. Just I need a little more time to finish the front wall and get the roof on and the back walls. And then
All
I
right.
think I should be in compliance once
Then,
I get the roof.
Board, do you have any questions for the
I have
violator?
a question. What do you feel is a reasonable amount of time?
If I can get the stucco done to I think another 2 months, a month or two, and then, but if you give me 2 weeks, I mean,
2
weeks.
months is what you're saying would be a reasonable
I mean, the
amount of
building
time?
inspector knows better than I do. I mean, I'm not a builder, I'm a lawyer. I mean, I didn't know, how many hoops I had to jump through.
Okay, well, let's ask, can this thing be taken care of within the course of 2 months?
It should be. He still has a lot of work to do, but they've done a tremendous amount. But I would think a 60-day time frame should be.
Or if you give me
adequate.
90
Be-
days.
Should be, is 90 days, yes?
I would say 90 days, because if you run into rain or
Excuse
any
me.
type of issue, you could be prolonged.
Okay, so 90 days is pretty much takes away any
More
vague.
realistic, yes, sir.
I think so.
Board? do you
Chairman,
have any-
I have some questions for the
Okay,
gentleman also.
Becky and then Justin.
Mr. Lindakis, do you have any more permits you're going to need to apply for?
Just I got the general permit, and then I think the electrical and the AC guy has to come in and get their own separate permit, and then also the roof. But those are the major permit has been pulled.
Okay.
And I also had to get an asbestos thing that took 2 weeks to get done, which I got that all done, the survey. So those are the only last 3 things to do.
Well, if Anthony says 90 days, we'll do it. I'm pretty much in favor. Justin, you had some questions?
I do for Mr. Lindakis.
Lindiakis.
Sorry, Justin. How long have you owned the property?
I've owned the property for 7, 8 years, whatever. I don't know
Is
the
it
exact
7 or 8 years?
I don't know the exact time I bought it.
Can we assume it's 8 years?
You can assume whatever it is.
Okay, and how long has it been unoccupied?
It's been unoccupied since I bought it.
So it's been unoccupied for 8 years?
Yes.
And has it looked more or less the way it has right now for the
Yes,
last
it
8
has.
years?
Yeah.
So in other words, you've had 8 years to make these repairs?
Look.
Just a straightforward
No,
question.
I-
Have you had
no,
8
I
years to
had
make these
from
repairs?
this year when the city told me it was in despair. Nobody told me 8 years ago I had to fix the building.
Didn't it have a violation and the facade fell off a few years back?
Never.
There haven't been facade repairs done on the building before?
Never. Nope.
Okay.
All I did was
So
put some paint on it.
just to repeat, you've owned the building for 8 years. It's been in the same shape it was when you brought into violation for 8 years.
No, I disagree with that. After that bomb went off, that crack got bigger, and that's when they came in January is when they came over here telling me the building was going to fall down. So it
When
was-
did this bomb go off?
Hey, look, I don't know when the bomb went off. The city came to me in
It
January.
was around December of 2011, and then...
So
yeah.
about 2011, 2012?
No. It's city, it was because of the Greek bomb that Mr. Lindiakis had come before us. When the Greek bomb had gone off, I think it was a Christmas thing. I think, if I
It was
remember
an Easter
correctly.
thing. Okay.
No, I didn't mean to
Easter- an
pinpoint.
Easter
I
thing.
just wanted to
Yeah.
make sure that the board understood that the real time frame that has been
Oh,
involved.
you got it wrong, sir. Can I tell you why?
No,
Because,
no,
he's trying to interrogate me,
Yeah,
and I
okay.
saw what he was capable of doing last time. Okay? They came to me in January of this year telling me that there was a crack they were worried about, and they were worried about the roof. They didn't come to me 9 years ago when I bought the
This was
building.
January of 2013?
Yes,
that they-
January 2013, okay? So
Okay.
don't put it back with your own little time frame, Mr. Vesey, okay? You wanted to find me the same day.
All right, any other questions?
I guess I'm a little confused here. I thought that the beginning of this was to determine if he is in violation or not in violation. And, I
No,
mean,
he's in
if he's in
violation.
compliance, I'm sorry,
Yeah.
in compliance or not in compliance, and he's not in compliance, so don't we need to find him not in compliance and then extend the time or, have a new motion to extend a compliance date? Or does he understand that if the fine starts because it's not in compliance, that he can always come back and ask for a reduction?
Well, let's see what
you're
Tom
really
has to say.
getting
Let's see what Tom has to
onto
say.
us about, we're just following the rules as we know them.
Tom?
Your options are to find him in non-compliance. When the property is brought into compliance, Mr. Lindiakis can come forward and ask for a reduction of fine by way of a petition for reduction of fine under the rules. The other option is to, and you don't normally do this, although the city of Dunedin does it all the time, their code enforcement board, and that is that they hear that there is a request for more time, and that their motion would be to extend the compliance date to whatever time frame. You can do that as well. So, or your third option is to find him in compliance. You haven't heard that testimony, but that actually is another option. So,
But
The
we have
reason I
had
had asked
testimony
it-
that he's
yeah.
not in compliance.
He's not in compliance, but the reason that I had talked about the 2 months and then 90 days after speaking with Anthony is to skip that interim step. And so if we would extend this for 90 days, then we skip that interim board step. And basically, we have a headway being made on the building, and I trust Anthony's suggestion or intuition with regard to the amount of time that it would take with permits and everything else. And I'm not interested in who's right or wrong right now. I'm interested in getting the building into compliance and beautifying our city. So I'm going to close public testimony and have somebody make a motion on this.
What are we making a motion to
Well, you
find?
can,
Is it
again,
in
I
compliance
would
or
make
not?
a motion myself, but, you can find them in,
Okay.
out
I
of
make a
compliance. or-
motion that the respondent is not in compliance. Should I read the case number?
Okay.
I make a motion that case number 13-800, 00342 is not in compliance.
I'll second that.
Yeah, you need to just finish it.
Oh,
no, that's good.
That's good, okay.
This is an affidavit, it's not a violation.
All right,
And there was a second down there somewhere, I heard.
somebody Al made a second? Okay. All right, board discussion?
I think the only question is, how much more time do we want to give him?
Well, no, you don't, this isn't,
It'll be a
Oh,
separate.
he's not in compliance.
yeah.
Yeah, okay.
And so he gets a daily fine until the building is brought into compliance. So that daily fine, did you say a fine?
It's $75 per day.
Pardon?
Fine, $75 per day.
Okay, so if-
Starting November 16th, 2013.
So if it's 90 days, do the math, and that's what the fine would be.
If we have 90 days, we'll fine him 90 times 75?
90 times 75, that's correct. I mean, however long it takes to bring it into compliance. Again, that's how come I wanted to extend, but Wanda has a valid point,
Yes, she does.
so
So that would have to be voted on before somebody.
if the
can make a
motion fails, then a new motion could be made to extend the time.
I guess my thoughts were that if we find him and that it is in non-compliance, then we do another motion extending.
No, that wouldn't happen. He would have to be brought into compliance.
That's what I thought Wanda was
And
saying.
so
Okay, yeah.
he will have $75 a day fine until the building is in compliance.
Yeah, but we can't find him in compliance if we've got testimony that he's not in
That's how come I
compliance.
wanted to eliminate that step.
Well, can we go to that
90
third
days.
choice?
Pardon?
And just indicate that we're going to extend
They
the time for compliance by 90 days?
Why can't we do that?
I think we have a motion on the floor that needs to be voted
Yeah.
on.
Well,
It's been motioned and seconded.
This is a separate motion.
I
This
understand that, but if you can explain how, or ask the attorney to explain how we could come to that third alternative so that everybody understands all the alternatives, because I'm not sure that even though we have a motion on the floor, that the motion was made in consideration of all three possibilities.
The motion on the floor would have to be voted down,
Okay?
and if the motion was voted down, then the next motion would be, if you're thinking about extending the time, the motion would be to extend the compliance date to whatever the date certain is.
Okay.
And so literally, there would be an order that would be entered that would be very similar to the order that was entered months and months ago, where it said the compliance date was November 16th, and now there will be an order saying that it will be until whatever, February 16th, March 16th, whatever 90 days works out to.
I would withdraw my motion. I guess
Okay,
I
I'll withdraw
kind
my
of
second.
Okay.
misunderstood.
I'll make a motion, if I could. I'd like to make a motion that in this particular case, the time of compliance be extended from the November 16th date as originally stated until the date of March 16th, 2014.
I'll second that.
March 17th, maybe,
We
Monday?
can make it March 17th,
Well, St. Patrick's Day.
Okay.
We could celebrate.
2014.
Do we have a second?
Second.
Okay, board discussion?
I have a question, I'm so sorry. Will there be a fine attached to this if a compliance date of March 17, 2014 is not met?
No fine.
Are you putting a fine to that?
I would want the same fine that was in place, but he has 90 days where it's not in place, but on the 17th, if he's not in compliance, then it would
$125 per
be.
day would begin, just like I was.
Would that be
Basically, just an amendment
retroactive?
of the original order. The original order, the only change would be made would be the date of compliance. It would be exactly the same order. Okay.
Board discussion? Justin, you were saying something? No?
And that would be March 17th.
2014.
When, if he's not in compliance, then the fine starts.
That's
correct.
$75.
Correct.
Not
Correct.
retroactive
No.
or anything?
Correct.
Thank you.
Now, I do have one more question, though. If he was supposed to be in compliance on November 16th, so does that $75 a day fine that's been going from the 16th, is that cast off, or is it still in effect?
You've changed the compliance date, and so
Okay.
there is no fine running.
Okay.
It will not begin to run until March 18th, 2014, if he's not complete by that date.
Okay, thank you.
All right, Bobby, roll call, please.
Mr. Plunkett,
Yes.
Mr. Solesky,
Yes.
Mr. Demosas?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
No.
Ms. Casey?
Yes.
Mr. Sansoda?
Yes.
Thank you.
Okay, now, is there anybody else in the audience for the affidavits of noncompliance? If I could have a motion to accept the affidavits of noncompliance, please.
I move to accept the affidavits of noncompliance on case number 13-200000026, 13-800000754, 13-800000782, 13-800000843, 13-800000858, 13-800000886, 13-800000988, 13-800000999,
Do we have a, oh, sorry.
and that's it.
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Affidavits of compliance. Is there anybody in the audience for the affidavits of compliance? Motion, please.
I move to accept the affidavits of compliance on case number 12-800000847, 13-200000026, 13-200000034, and 13-800000679, 13-800000988, and 13-800000999.
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries. Item number 23, thank you very much for your patience. If you would please come to the microphone and state your name and address for the records.
William Ziering, 900 North Pinellas Avenue, the restaurant.
Thank you, Mr. Zurich. And Anthony?
Now, hold on, this is a
Oh,
petition for reconsideration of fine.
That's
You're
right,
not going to
that's
hear
right.
any testimony, you're not going to hear any comments.
Right.
You're going to make your decision based solely upon the written petition, unless you have a question of either Mr. Elliott or his client
Or the city, yeah.
or the city.
You all have the paperwork in front of you, correct?
I do not.
We got ours by email,
Okay.
so we don't have any paperwork.
Although I read it,
Yeah.
I didn't print it and bring it.
I'm going to give you a stack of it. Now, I've got a couple of extra copies here. Here's one set.
That's all one.
Thank you, Tom.
If that's just what was in the, that we got in the email,
Thank you, Tom.
thanks.
Okay.
So should we just discuss?
Yeah, board discussion on this. We're looking at entertaining the possibility of a reduction in fine. You have the violators' desire for a reduction to administrative costs.
What was
And
the fine?
I don't know what the original fine was, but
Bobby will have that.
I'm sorry,
What was the fine, Bobby?
$42,000?
now, the city asked that the fine be imposed. At a time there, a suggestion was made by a previous volunteer for the violator for $5,000, but the new desire is to bring it down to administrative cost, which I don't know if we have administrative costs. I'm guessing it's probably, do you have any idea what administrative costs would be, Bobby?
That pretty much would come from the development service area because of their cost of inspections and that sort of thing. The clerk's office has a cost, but
Okay.
I
Okay.
would be my guess that it wouldn't go over $5,000 though for a few inspections.
Justin, were you about to say something?
I was going to ask, can I ask a question of Mr. Elliott? Is it the right time if I wanted some clarification? Mr. Elliott and the owner. Mr. Elliott, Mr. Ziering, Justin. I'm a little weak on the timeline and the sequence of events that actually occurred. Could you give me a synopsis of exactly what occurred and when and why you're here today?
Sure. Herb Elliott for the property owner, Mr. Ziering. And I'm going from memory, I didn't expect to testify. This board let's go back to, let's say, September of last year. And, well, let me give you an exact date.
And before you go on there, Herb,
Sure.
he's not testifying, okay? He's a lawyer. So the factual information you hear is argument. It's not the facts. And if you have questions of his client as to the facts, the client can answer them. But Mr. Elliott can't testify under oath as to the specific facts. So,
Well, I'll give you some facts to my personal knowledge. The property was purchased by Mr. Ziering on August 31st, 2012. This is a property, vacant parcel just across Live Oak from Ballyhoo Restaurant. Shortly thereafter, the manager started using that property for vehicular parking for patrons at Ballyhoo Restaurant. He was cited for a violation because a conditional use was not then in effect. Came before this board pursuant to that the notice of violation, and that was in September, I believe, of 2012. Immediately thereafter, the next day, according to the documents that are in your file, Mr. Fregali, who was here before previously, stated that the parking had ceased to be used. No more parking at the property. That was the main aspect of the violation in my judgment, people parking there. There was also some millings that were also put in for the parking, also without a permit. Those millings were removed December the 21st, 2012, according to the documents that are in your file. This board gave Mr. Ziering 30 days to come into compliance, or 60 days, was it December?
I'm not sure.
The day you called today?
I called today, the deadline was December 13th.
Okay, he was given a period until December the 13th to come into compliance. He came into compliance, in fact, a month prior to that, December the 21st. Problem was, Mr. Fregali did not call in for a reinspection. The documents that are in your file there state the reasons why Mr. Fregali, under oath in his affidavit, said he was not familiar with the procedure. He was very busy. He ran 5 restaurants. Apologizes. But the issue is, was the property in compliance? In fact, the answer was yes, well within the time period. Does that answer your question, sir?
I believe so.
Okay, that being the case, then, Anthony, I would like to have a question of the city with regard to what was just testified. There was no conditional use permit applied for. They were in violation. They were given X amount of time. Did they come into compliance in a timely manner?
No, they did not. There was never a call for an inspection.
Okay, now, never a call for an inspection from the previous owner or from the...
They were all notified on the
Speak
paper.
right into the microphone.
Oh, sorry. They were all
notified as in all, including...
Everybody
Okay.
was notified, all parties concerned. And in that notification, there is a sheet that code enforcement attaches that indicates the requirements.
So
for
Mr.
payment.
Ziering was notified as well?
Yes, William Zering, P.O. Box 8435 in California. The Zering Trust, Ballyhoo, and the original grill was notified.
And
We were all notified, and on the first page of the notification says you have to call in,
yeah.
and it's in compliance.
Mr. Chairman, I have a question when you're finished,
Okay.
if you're not. Just so I understand, Anthony, so the crux of the fine is not that they continue to use the parking lot, not that they didn't remove the product, but because they didn't respond to the final letter and didn't call in for a final inspection. It's not that they kept using it, they quit using it right away, it's just that they didn't make that last step and have you inspect it and say it was okay? Is that really what is at issue here today?
Yes, I'm not sure when the millings were removed.
Because you were never called for a final inspection.
Yes, sir.
Just out of curiosity, do you have any idea what administrative costs are?
I have not calculated, no, sir.
When were you notified that it was in compliance?
Oh, boy. We have that one, so. It was probably just before May 31st. The gentleman who ran the restaurant actually phoned me personally at the city And then the next day, I believe Richard Haig, senior engineering inspector, had gone out and placed it in compliance.
What year?
That was 2013.
Okay. What's been going on?
Well, you know,
So we're looking at what day? Is it the next day?
I'm sorry, Al, what?
I'm just asking if that was the next day that Mr. Haig went out to check it.
Oh,
No, the
You
next
know,
day
I
after
was
he called.
privy to that board meeting. I know we've had some change in faces in that gentleman before us. And I believe that he was fairly clear that those deposits had already been removed immediately, that the parking lot wasn't being used and had been returned to its natural state as quickly as they realized that they weren't allowed to be there.
well, I think it's entirely likely that they came into compliance
I thought they
quickly.
came into compliance just one day after the notice, but they didn't fail, they failed to notify us.
To notify.
So we're really talking one day.
Can I answer
well,
that?
okay.
Hold on a second. We're not
Yes.
taking narrative back and forth, and so if there's a specific question, you can either ask Mr. Elliott and his client, or you can ask the city, but we can't be having everybody respond to thoughts up here on the board. So that's why your rule is the way it is. You can ask specific questions, so.
Normally, we just keep this among the board. Justin opened it up, but actually in this situation, I agree with Justin opening up the dialogue. Now, among us, okay, we know what the city wants. The city wants the fine imposed. And, you know,
I'm willing to make a motion, Chairman.
I don't know what the city wants, Mr. Chairman, but it seems to me that we're talking one day.
well, okay, Justin, go ahead and make your motion, and
Would this be under new business call for motion?
I think you just wing it.
Just
what is
wing it,
this? Which
okay.
one are we using?
So I move
It's
based
a
on the
fine
testimony.
reduction. You have a motion for fine reduction.
Thank you,
And that's,
Mr. Kress.
Turn it
Of course I
back.
did.
That's
That's
what
why I
this is.
asked.
Okay. If you want to
Oh.
use that form.
Last page.
Old business, petition for reduction of fine, motion for fine reduction. I move that a fine of $1,000 in the case of citation number, excuse me, I need to start again. I move that the fine of $42,000 in the case of citation number 12-200000026 be reduced to $1,000. This reduction will occur upon payment of the stated reduced amount, if paid within 60 working days of this order. Failure to pay the resulted fine will result in the original amount of $42,000.
Do we have a second?
Second.
For discussion?
I didn't understand the whole thing. $1,000
The
for what?
$42,000 fine reduced to $1,000. I'm a little concerned that it wouldn't cover the administrative costs.
Administrative costs are $250.
Why would,
This has been going on for a while.
That's what it was.
That, according to the city thought that $5,000 would cover administrative costs when the city testified.
Who the heck's gonna
Administrative cost isn't a flat fee of $250, it's man-hours, and it's an assessment of. Wanda?
I'm having a problem with it going that low. I would go like at least 10% of the original 42. We have in the past asked to show some kind of hardship for a fine, and we haven't gotten that. And I think that
We're happy to answer that question.
no one's addressed, no.
we, you know, in the past, we've asked people to send in their, tax returns. And And I believe that the people that are, looking at the fine are notified of that. And you guys, these people
Well,
don't
this-
read
yeah.
directions. They didn't read where they were supposed to let Anthony know that the thing was in compliance, and they didn't send us anything showing financial hardship. So I have a problem going down to $1,000.
Well, that's okay, I
think
mean,
Mr. Elliott's letter did actually address financial hardship.
Well, it says that they'd have to close their doors, but they didn't show,
all right,
they didn't
so,
show me proof.
so Wanda's reservation is not proof of a financial hardship. Any other board discussion on this? All right, we have a motion and a second. Bobby, if we could have a roll call vote on Justin's motion.
Mr. Plunkett?
Yes.
Mr. Swalinski?
No.
Mr. DeMasis?
No.
Mrs. Archer?
No.
Mr. Bessie?
Yes.
Ms. Vacacy?
No.
Mr. Sansoda?
No. Okay, the motion failed.
You want me to make one?
Yeah, if you want to make another motion.
I move that the fine of $42,000 in the case of citation number, oh, God. All right.
There you go.
Oh, okay, thanks. 12-2-0000026, be reduced to $5,000. This reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount of $42,000.
Do we have a second?
I'll second Wanda's motion.
And board discussion. Wanda, if I could see your paperwork on the
Oh,
board discussion.
Does this cover expenses and all that the city has done to try to get this taken care of? I mean,
If it's just
It's been going
discussion
on for over
between
2
us,
years.
I would
Or
think that it's
over a
probably
year.
multiple times what the
I-
true expenses are.
it didn't require, 8,000 trips out to the site. If,
In fact, there's probably been no
I-
trips out to the site. That's the whole idea. is
Right.
that
I-
It wasn't
I-
any final inspection call.
my guess, Becky, based on some of our other cases that I, recollect, that that should cover that completely.
Any other board discussion? Okay, Bobby, if we could have a roll call. This again is for a fine of, I guess, a fine and administrative cost for a total of $5,000.
Mr. Plunkett?
No.
No? Mr. Swalinski?
No.
Mr. DeMasis?
Yes.
Ms. Archer?
yes.
Mr. Bessie?
Yes.
Ms. Vacacy?
Yes.
Mr. Sansoda?
Yes.
Motion carries.
Okay, motion carries, fines reduced to $5,000. Thank you, gentlemen. With regard to, there's no minutes from last month. Are there any public comments at this time? Board and, I'm sorry, Mr. Elliott, yes.
Yeah, I'm here as a private citizen. My address is 1111 Riverside Drive. And I have some thoughts about your procedures. I'm more in a position to be able to write documents than most people. I have a secretary and printer and so forth, but it bothers me to see people's mouths being shut when they have the opportunity to speak before their government. I've been involved in Tarpon Springs government for over 38 years, and only once I've ever seen anybody refuse to speak, and that was me. The mayor refused to let me speak at a public hearing about 20 years ago. Our citizens don't like to be shut up, and often when I sat behind your table, I didn't like to have to stay there until 2 or 3 o'clock in the morning, but that's your job, is to listen to people. and often the written word doesn't do as good a job as the spoken testimony. There was a motion made several months ago to continue this hearing. No opportunity to be heard on the motion. You're talking about people's property. They have an opportunity, I would think, to explain why they don't want to have this motion continued, the petition continued. Other people today were complaining about not being given the opportunity to be heard, which is arguably a constitutional right, to petition their government for redress of grievances. And I would hope that would include the ability to speak. Furthermore, another separate issue, the city starts off with their presentation, and then the board is asking questions of the city staff and often making conclusions based upon one side of the evidence. I would urge you to consider the possibility of change to your rules to let the city speak, give their case, as we do in court most of the time. The judge listens to one side, listens to the other, goes back and forth, then asks questions. That, to me, is a fair way of going. So I would urge you, if you do consider the rules change, because you didn't look very good today, and I appreciate your motion, but there's a lot of confusion, and it's somewhat embarrassing as a private citizen to see what was going on here today, with all due respect, because this board does do a very good job, and the city's a lot cleaner than it used to be. When I first started, when this board was first authorized in 1992, I believe, 1982, the board said, the city commission said, no, our city is too buddy-buddy, we can't have a code enforcement board, and they didn't have one for several years. And then second time around was passed. But I would urge you to have the cities make their case, then listen to the petitioner, then maybe ask questions, because you're kind of making a decision based upon one side. And I heard some comments from the board based upon the city staff that you're a violator and you were held in violation, and we haven't heard the other side yet. So on those 2 points, I would at least like you to consider having some changes made to your rules of procedure, and I appreciate your indulgence. Thank you.
I appreciate your comments. I do believe that the first opportunity to testify is the opportunity for the person who the city perceives to be in violation. At that opportunity, that person can speak publicly. And again, with regard to having let's say the defendant, if you want to, speak at the hearing, the situation that we just did today, we addressed, it was because the board found it prudent, even though you had submitted ample written testimony. If the board considers that testimony to suffice, then basically it's not open to a second round of public discussion, because the time constraints in doing so, it would be considering the case all over again 100% from start to finish. But again, these procedures are all voted on and they're modified accordingly as folks see fit, and your suggestion is now a matter of public record. I appreciate you taking the time to do so. With regard to the city speaking, once the city finishes, and again, at the very beginning of the procedure here, the city speaks, we ask questions of the city, and then the violator speaks, we ask questions of the violator. And I would agree with you, if we would make a decision based on just the city without taking into consideration the violator before he or she was able to speak their testimony, then we are indeed in error. I do not believe that to be the case, but I appreciate you making us aware so that we can be more keen in the future. Thanks again, Mr. Elliott.
Thank you.
Board comments.
Yeah, I have a comment. I think that the best advice we're going to get is from the board's attorney, and if he indicates how the procedure is supposed to be carried out, I think that were right in following his instructions despite what anyone in the audience might feel. And I think rather than have chaos or modify it because someone brings an attorney or somebody wants to speak or somebody wants to make a speech from the floor, I think we have to be governed by certain rules and instructions. And I don't think that we can get better advice than we could to follow a procedure that's outlined by the board's attorney. And that's what I think we were attempting to do. And that there's going to be people, especially attorneys, that want to earn their pay in front of their clients. I was a hearing officer for 22 years in the railroad industry, and I saw it happen there time and time again. And I still feel we have to follow the procedures for this type of proceeding. I think that the chairman has attempted to do that. And whether we sometimes argue amongst ourselves, we all have the same goal, and that's for the benefit of Tarpon Springs. That's how we start our meeting, with a prayer. And I think every one of us in good conscience has tried to do that. And there's going to be people in the audience, there's going to be people who come in front of us that aren't going to be happy. But nonetheless, I think that as this year is our last meeting for the year, this date, I think we've done a good job this year. And I think that we're looking forward to another year. This was a little bit contentious. We had one person in front of us that basically threatened us that we're going to go to circuit court, et cetera, et cetera. We had this gentleman waving the flag about what good citizenship should do and that we didn't give people the right that they deserve in front of us. And I think we have. And I think that we can all hold our heads up when we leave today, that we've done another good job. That's all my comment for today.
Well, let's just be honest. I wholeheartedly rely on Tom keeping us on the straight and narrow, and I do believe we do an outstanding job as a board. I think we have a very diverse board that considers a very strict interpretation, a very liberal interpretation, and I think that the decisions are to the betterment of Tarpon Springs, and I think it's a bang-up job that we do. Thank you all for your service.
May I add just one? Mr. Trask, the rules and procedures that we follow, those are our own created rules and procedures that we follow, if I'm not mistaken. And thus, it's not a magic book in the sky. If we as citizens and board members feel that we need to adjust or modify or change for the better those rules and procedures, we can. And that's kind of our job also. Now, no changes need to be made. We just roll on down the road. But he's there to help us interpret the rules that were laid down by previous boards. That means that perhaps Mr. Elliott had some good words. There might be one little nugget that might improve our efficiency or representation of the people.
Yeah, to answer your question, they are your rules. The City Commission didn't create them. This Code Enforcement Board created them. And they may have been drafted by Mr. Elliott when he was the city attorney, but they were drafted in 1989. They've been changed 3 times in the last 25 years, and there's only one provision in the entire rule book that has been changed, and that's the petition for reduction of fine. And it was changed from 30 days to 60 days, and there was a reference included to allow questions to be asked, like you did today, of the alleged violator in the city. So those provisions were added. But other than that, the rules have been upheld and followed for 25 years. There's been no problems with them. And if I could just indulge you for a couple of minutes, no one has a constitutional right to stand before you and testify. This is a quasi-judicial board. Mr. Elliott is confused. This is not the City Commission. People don't have the right to come here and talk about whatever they want. Now, earlier this year, there was a change in legislation that basically said that in public meetings, people have the opportunity to have citizens' input. But there was a major exception in the law, and that exception was for quasi-judicial boards. This is a quasi-judicial board. You have no legal right to come here and to talk unless you have been called as a witness or you're a party to the case. And so he's wrong. It may be nice to do that, but you wouldn't be doing your job because you're supposed to weigh the evidence that's presented before you, whether it's a document, a photograph, or testimony. And you can't be weighing evidence on people that just talk. they have to be able to provide you with some relevant testimony or evidence related to the case. So you're doing the right thing. If I thought that you were going down the wrong path, that's my job. I'm only here to make sure that you don't get any of your decisions appealed, so that due process is given in each one of the cases. And you guys handle hundreds of cases, and you've probably had 3 appealed in the last 20 years that I've been sitting here. So you've got a really good record of, following the law and doing the right thing. So, and as for the discussion relative to the petition for reconsideration of fine, there's a reason. I think the legislative intent, the reason that provision was put in your rules back many years ago, and by the way, it's in every city that I do. There's the same rule. Because you shouldn't have to have the case presented to you over and over and over again. You hear it at the initial case, you hear it sometimes at the compliance, non-compliance hearing, then you're going to hear it again at a petition for reconsideration of fine. You'll never get anything done, because every single person that ever has a case prosecuted here, they're going to get a shot at it 3, 4, 5 times. They're going to argue the same thing. And that's really not what it's all about. So I would caution you on changing that, unless you want to be here till like when we first started doing these meetings, 7, 8, 9 o'clock at night, rehashing the same thing over and over and over again. And I would suggest that that's not something you want to do. Since for 25 years, the process has been working great. Nothing has changed. The city looks great. You're doing everything that you're supposed to do as board members. So I don't know if I would direct you to go down that path, but you're the ones that make the decisions as to what you want to do with your own rules. So, all right, I'm stepping off my soapbox.
Thanks.
Thank you, sir.
Thanks for your expertise. Any other public comments? Board comments?
Mr. Chairman, are we supposed to have an election today?
Yeah, we will be.
Okay.
Anything else? All right, with regard to the election, we need to elect a chair and a vice chair. And I'm open for, in fact, maybe I've got to say, if there's any sloppiness on this board, it falls on my shoulders. So it's an opportunity here for you guys to reconsider your chair. Having said that, again, I do appreciate your service. And you know what? I know we have our disagreements, but we all come together and we all make a decision, and that disagreement's behind us. It never lingers. So thanks for your input. With regard to chair,
I'd like to motion that Mr. Sansoda remains as chair for the year 2014.
Second.
I would first like to ask, is Mr. Sansoda willing to accept the nomination for chair?
Too bad.
Before we nominate.
I am willing to accept the nomination for chair.
All right.
Are there any other nominations for chair? Then I guess, what we do, a roll call vote, or all those in favor? Usually I'm absent these days.
Yeah, we'll go ahead and do a roll call vote.
Okay, Bobby?
Mr. Plunkett left.
He had to leave for a doctor's appointment, he said.
Mr. Slipinski?
Yes.
Mr. Demasis?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Casey?
Yes.
Mr. Sansoda?
Well, yes, thank you very much for your confidence in me. And do we have any suggestions for vice chair?
I would like to nominate Justin.
No one asked me if I wanted to do the job.
Well, I was just getting ready. Just gonna wait and see if you said yes or no.
I'd be happy to be the vice chair for next year.
Need a second then.
And
Second.
Oh, I'll second. Okay.
do we have any other suggestions for vice chair? Wanda, Bobby, if we could have a roll call, please.
Yes, sir, one. All right, Mr. Slawinski?
Yes.
Mr. Demasis?
No.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Ms. V. Casey?
Yes.
Mr. Sansoda?
Yes.
Motion carries
I'm sorry to lose you as a neighbor, Wanda, but,
5-1.
Okay, well, thank you very much. I hope you all have a wonderful Christmas and a wonderful New Year. We do not have a code board meeting in January, so our next meeting will be the second Thursday of February. It is 3:45, and our board is adjourned.
Oh, I understand.